Good morning, everyone. Thank you for joining us in another session of Back to Basics Practice Management. Our topic today is physician contracts, and I'm excited to have with me today Karen E. Davidson, Esquire, and the topic that we're going to have today. And let me just tell you a little bit about Karen. Karen Davidson is a healthcare attorney with over 25 years of experience representing physicians and other licensed healthcare providers. Ms. Davidson devotes her practice to serving the legal needs encountered by her clients on the business side of medicine. Towards that end, Ms. Davidson provides legal counsel in connection with employment and service agreements, medical directorship arrangements, employment termination, and or practice separation matters, hospital contracting, practice acquisitions, mergers and sales, compliance matters specific to Stark fraud and abuse, HIPAA, joint ventures, insurer contracting, ACO arrangements, and other regulatory and transactional matters arising in medical practice. Ms. Davidson started her career as a scientist working as a research associate at the Wistar Institute and Wills Eye Hospital in Philadelphia, so she understands the complexity of medicine and healthcare from the scientific and legal perspectives. She lectures regularly, seeking to provide practical insight into the dynamic regulatory scheme in healthcare and the business aspects of medical practice. Ms. Davidson is a graduate of Temple University, Beasley School of Law, licensed to practice law in the Commonwealth of Pennsylvania, State of Maine, and District of Columbia, and a member of the Bar Association in those jurisdictions. Ms. Davidson serves on the board of directors of the Southeast Pennsylvania Area Health Education Center and is a member of the American Health Law Association. Today, we will be speaking with Karen about physician employment contracts in an effort to understand how these contracts operate and affect physicians. This is an informational session, and if depending on your circumstance and situation, if you need to seek legal counsel, please do so. So without further ado, I am really excited about my guest. Her array of expertise is tremendous, and so I'm so excited about this conversation and hope to help other clinicians out there in the world of physician contract. Without further ado, here's Karen. Hi, Karen. How are you?
I'm good. Thank you so much for having me, Sharon. This is an honor to be able to be here with you and talk to your audience. And would love to invite anybody to ask questions or put questions in the chat if they're able to do that while we're going. I know we have a half an hour, so I want to make full use of our time.
Absolutely. So please do so. Put your questions in the comments. We will check that every now and again and make sure that you get your questions answered. So let's start with my first question. What are the considerations of a physician contract?
So that's a really great question, because what I like to try to do when I'm explaining or responding to something along those lines is to really give you my philosophical perspective on these contracts, right? So I do a lot of speaking to groups, and what I try to do is first understand how these contracts are built. For me, they sit on four principal pillars. And the first pillar, of course, will come as no surprise. It's compensation. And from a compensation perspective, I look at survey data for physician compensation all over the country, because I do represent physicians all over the country, and look at not only what the compensation ought to be, but what is lining up with that, whether it be some sort of production related to collections. And when I go into the database, the one that I use and subscribe to is the Medical Group Management Association. It's called their Physician Comp Survey Database. And we do the data dive. And I go in, and when I'm mucking around in there for a physician, I try to pull as much data as I can, including perhaps the number of encounters and things of that sort, or work relative to units. We call those work RVUs. And work RVUs are something that line up with every type of service that a physician does. When you have a current procedural terminology, a CPT code for a service, you see a patient in the office, depending on your specialty and depending on the severity or the comorbidities for that patient, you may have a certain level of that visit and there are corresponding work RVUs. So when I talk about compensation and I'm trying to explain that, I always want to make sure we're starting from the same understanding with the client, because a lot of these physician contracts go through base compensation will usually be set for some period of time, maybe 1 or 2 years, with a possible productivity bonus that could be related to production, whether it be work, RVUs, or collections. And or there may be some detrimental compensation effect in, let's say, year 2 or 3, if the physician didn't reach the milestone for the benchmark of the production. So there's a lot of discussion. So that is really, again, that principal pillar of of the 4. The second one, in my mind, is term and termination. How long is the contract? How do you get in? How do you get out? What kind of notice needs to be provided? Usually employers have the ability to terminate a contract if there's something egregious like a lost license. But they also may say, on the one hand, oh, we're giving you a 2-year or a 3-year contract, but the reality being either the physician or the employer can terminate on 36.
Oh, no.
So in those situations, it's really important for the physician to understand, oh, for example, my goodness, I'm moving across the country to California. I can be terminated on 30 days notice at any time, but I'm moving my whole family there. And that doesn't give a strong sense of security, going forward. So that would be, and these aren't necessarily in order of importance, but I would say the third pillar for me is I'm always looking at the professional liability insurance. And there are essentially 2 types. The first is the longest sort of lasting, shall we say, is called occurrence type of coverage. And most physicians understand that it doesn't matter when a claim comes in. If you had occurrence coverage under a policy, you're covered, even if you're not under that policy anymore, or you're not working for that same employer. If you have claims made based coverage, upon termination of employment, when you leave and go leave that policy, then somebody, and that's the question, will need to purchase what we call formally an extended reporting endorsement, which everybody sort of knows colloquially as the tail coverage. Tail coverage is something that needs to be purchased very quickly after termination, 30 or 60 days, or it might just not be available to you. And it usually runs somewhere around 100 to 200% of what an annual premium is. So it really behooves the physician to know, going into a contract, whether or not they're responsible for purchasing the tail. Now, the extreme situation is in obstetrics and gynecology, where tail coverage can be upwards of $100,000 for even after 1 year of, or less than a year of practicing medicine. And so I've been involved in situations where that almost de facto makes it that the physician can't leave. So there's a lot of issues around that. So that would be, from my perspective, the third pillar. So that was compensation, term termination, professional liability insurance. And then we have what I'll call the broad category of restricted covenants, which most people think of non-competes, which is usually for some period of time, for some distance or county or locations, the physician will be restricted from practicing medicine. So, it's very important to understand what the implications might be of a non-compete in particular, so that you can make very practical decisions about, my goodness, I typically ask people, you need to be thinking about where you can work if for some reason you leave this position. And so again, that very pragmatic side of me says, okay, well, you've got a 15 or 20-mile non-compete in your particular area. Where do you want to live? And what happens if
Right.
you need to leave that position? So those for me are the big foundational pillars that these contracts are using to convey these terms. And you might have another 20 some odd pages of lots of language, but ostensibly that's what they're built on. There are a few others where there's some liability shifting to physicians, but we're getting, I think, ahead of ourselves given that we have just a limited time today.
So what I'm hearing is that those four pillars, at the very least, is something that the physician should be honing into their contract. Like those are your basic four pillars. Is that how I hear it? That in what we're leaning to about the physician contract.
I would say yes. And again, what I try to do is take, for lack of a better description, a holistic, pragmatic perspective on the analysis. So when a client and I are reviewing an employment agreement, or even a medical director agreement, or any other sort of physician contract that's out there, we're looking at how much they're getting paid and what kind of work they're doing to get for that, how much call they might have, how many locations they're going to be in. We're looking at how long the contract is for and how can they get out, or what kind of security they might have for the length of the contract, if any. We're looking at professional liability and who's going to be responsible for anteing up for tail coverage if that comes about. And we're looking at where they can practically go work if they were to leave the position. So those are four really important criteria when analyzing, and physicians often have more than one job offer on the table when they're looking. So
Right.
it may be very important to not just look at only the dollars, but if the
Right.
dollars represent more clinical hours or more locations because you're going to be traveling here and hither and yon to get
Right.
to this, which is going to eat up your production time, right? So,
Right.
so there are, in that regard, I try to get very holistic and practical about how is this going to, what life impact is it going to be, and also does it make sense to be asking for? Because you cannot negotiate a contract or know what you want to be changed if you don't understand what's been presented to you.
Absolutely. Absolutely. Great points. Um, my second question goes into line of how do you navigate with a non-compete?
Well, that's a very important question and a very pertinent question right now. Okay. So
Okay.
there's a handful of states where non-competes are unlawful. And over
Hmm.
the past 10 years, there have been a variety of states that have put some limitations on non-competes for physicians. Now, within this dynamic, we also have that the Federal Trade Commission last year came out with a proposed rule banning non competes. Now, you have to remember that the Federal Trade Commission only has authority over for profit entities. So, any of those nonprofits or health systems, 501c3 organizations, they're not going to be impacted by the Federal Trade Commission rule. Now, it's been a year, and you can imagine the ruckus that, the brouhaha
I'm sure.
that happened
I'm
after,
sure.
and all of there were a lot of national organizations that have, submitted comments. So we are anticipating a final rule or something. Not, they're not obligated to do it, but we were anticipating something this month of April. So we're, waiting for the other shoe to drop to see what happens. And that rule would, if it passes, if they adopt it in the same form that they had previously, then non competes would be unlawful. for for-profit entities, and except in certain circumstances, let's say where a physician might sell the practice, and then under those circumstances, and maybe there will be other carve-outs. So navigating a non-compete in states where they're lawful, and I think we still have to be mindful of them, given that the FTC final rule hasn't passed, and many physicians work for either academic medical centers or nonprofits that are not necessarily academic medical centers, and those are still going to have to be navigated, is always that first question of, well, where could you work if you left here? And how clear is the non-compete? Because in a way, the person that you have to convince that that non-compete is not going to be a problem for you is the attorney for the practice you go to after you leave that job. So I spent some of my time trying to convince attorneys for the hospitals or the health systems or the medical practices that the language of the non-compete that's in the contract for the physician who wants the new job isn't going to get that practice in hot water by getting some sort of cease and desist letter that says, okay, you need to cease employing this person because they're already entangled with us in where they can find us. So there's that component. And unfortunately, with most physician contracts, there's language in that contract that says, oh, and by the way, if what you told us that you didn't have a non-compete that was problematic ends up being a problem for us, you're going to pay all our legal bills.
Oh, wow. Wow,
so
that's significant.
It's significant, right? So they can get you coming and going, and you have to be really, and that's part of, so when I have a physician, I work with a lot of mid-career physicians, junior physicians as well, but mid-career physicians that are leaving one position, whether it's academic to academic or academic to non-academic or vice versa. We're really parsing that non-compete and making sure that the position that they're going to be taking is not going to be violative. And sometimes that can be tricky because the language is written very broadly if, it hasn't been negotiated.
That's huge. I'm just thinking about it, absorbing what you just said. That's pretty significant, in terms of physician liability for what you just said, in explaining that. It just kind of put a shock. It just put a shock in, and I'm not even a physician, but it makes me pause and was like in the sense of that significant liability, and you're like, whoa, wait a second, I need to take a pause. Having said that, now, what are some, if we go to the employer side, what are some red flags we need to look out for? Is there anything additional that we talked a lot, and I'm sure our audience, I'm checking to see, I haven't seen any questions thus far, but okay. What are there in terms of red flags that we need to, key in and be mindful of?
So one of the things that I often say to folks is, before they've gotten the contract, there's been lots of discussion. And there might even have been an offer letter or a letter of intent. I'm going to put a pin in that. I'll talk about that again in a moment. But if the contract has no relation to the conversations that have been had about the position, then really that is something that needs to be brought to bear. Now, a physician might say, okay, I don't care which hospital they put me at, because especially if you've got large hospitals and health system, if it's an emergency medicine physician or an anesthesiologist, I'll go wherever they tell me. Great, no problem. But if somebody says, no, and I just had this conversation this morning, I really only wanted to be at X location, and the contract doesn't say that. In fact, the contract says they can put me wherever they want to put me. That leaves the physician with some discomfort. In addition, those locations can play into where the non-compete will apply. So that if you want to narrow the focus of a non-compete, sometimes it's best to work with getting the narrowing of the locations where the physician can render service, because the the restricted area would be around, let's say, the primary location where the physician worked. So that's how, when I talk about these four pillars, they often key into each other. So the red flag might be, for example, if you're an academic physician and you don't stay to the end of the academic year, you might also lose your bonus or your productivity, or
Mm.
or any other physician leaving before the end of a calendar year, or the year that's the contract year. So I say these contracts are very much like Rubik's cubes. They fit
Mm-hmm.
together in a very specific way. And so understanding that, so you can know what you're in for. And for me, it's all about the continuum of risk. Where's the physician's comfort level? So when I go through this with a physician about their contract, or they're leaving a position and going to the new one, we're often having these conversations where they might easily say, "Oh, because I'm here to present options and tell you what I've seen and done." They might say, "Oh, I'm not worried about the call. Did my residency and fellowship in the department. This is how calls always worked. As long as I'm responsible for the same calls everybody else, I'm good." And that's great. On the other hand, if your compensation is maybe on the lower end, and the
Mm.
call was told to you that it's 1 in 5 or 1 in 6, weeknights, weekends, and then all of
Mm-hmm.
a sudden it could go down to 1 in 2 because
Mm.
people have left or 4 people have left. Well, then does the compensation going to line up right at that point? So I would say that from navigating, you want to look at the whole picture and what its impact's going to be. And that probably leads me to this: for any new physicians, or even physicians that are mid career that are looking for new positions, often what they'll get is an offer letter. And
Mm.
sometimes, and most often these days, they're asked to sign the offer letter before they'll even get a contract to review. And so it can be important to get a sense with counsel as to whether the compensation that's being offered or the terms that are included in that offer letter. Because what typically I see happens is, if you sign that offer letter, but you try to negotiate something that was in that offer letter later, the response is going to be, "Hey, this is what we gave you, this is what you signed. We're not really willing to move on the compensation or the location or any of that when it comes to the contract."
That's really interesting. Interesting that the offer letter comes before the actual contract, but that's a very good point. To look at that. It sounds like before they make any signatures, or accept the offer, that this should be reviewed. Very
Yes. And
interesting.
I just had the, sorry, I didn't mean to interrupt, but I just had this conversation this morning with somebody who's looking at her first academic position, and they're coming up with a clinical plan for her. And we were having this conversation about, okay, while that plan can be changed pretty much at any time in any way, unilaterally, pretty much by the employer, really understanding what's in that plan could be important even at the initial stages. And also the allocation as to what your clinical versus non-clinical time if you're in an academic. And I wanted to mention too that the MGMA database that I was referring to does have a separate clinical academic database within the overall database. So
Mm,
there's
okay.
usually a big difference between an academic compensation and non-academic compensation. So non-academic is typically on the higher side, but that can also line up with higher production requirements of work RVUs or collections or things like that.
I see. So what I'm hearing from our, all of our discussion, and I'm checking to see if there's anything in the chat. So far, I haven't seen anything that pop up as questions, but I do want to recap that what sounds to me in the, in their process, as, wherever they are in the physician's life, whether they're coming to becoming an attending or moving about wherever in the, in employers and whatnot, that seeking counsel is something that they should consider. Really sit down, and talk about their planning. It seems like, and that you can plan accordingly of what your strategy or your move is going to be that would benefit you as the clinician, and what you're intending to do, as you said, for any matters that is going to pertain to their compensation, to their productivity, to their termination, and even considering um, uh, just being part of an academic health system, or being an independent, or being part of a any type of contract that they need. Did I hear that correctly? That the best strategy for them is to do that, so that as busy as their lives are, and as things get excited, depending on again where they are in their lives, and that take that time to really put that into before pen to paper is what I'm hearing.
And I would agree with that. I would say overall, it's that you want to develop a strategy, and you can't have a strategy unless you understand the contract that you have or that's being presented to you. And you can't compare and contrast one or two or three contracts unless you know how they're different from each other. So I would say that that is mission critical, is understanding the contract and its impact on your life, and developing a strategy for yourself. And I'll close with one thought that was conveyed to me by actually a coach for my business, which is, you are the CEO. And I know doctors don't think of themselves as having a brand, but even though, and I'm now I'm treading into your territory, Sharon, but
No, 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 not at all.
you are the CEO of your business life. And
Absolutely.
looking at your contract, understanding the business implications of it, it's completely foreign relative to your medical education, right? And so it's important to develop yourself as a business person. And that's why, thank you for reading my, introduction and the bio, but really it is the business of the practice of medicine. And the folks that you're going to go work for are sophisticated purchasers of physician services. They do this every day, all day. They negotiate these contracts. They have compensation committees. They think through what they're offering you. They know that they're building in profit for themselves, whether it be private equity, for profit entities, academic medical centers. Okay. So you need to have that similar, shall we say, bit of sophistication on your side of the equation.
I totally agree, Karen. And, I think that is one thing I believe medicine should also focus outside from just, clinical practice. While that is extremely essential and valuable, there is a business side to medicine. And it's critical for at least the understanding in the way of how business affects all of us, in healthcare. So I totally agree, and the more prepared that you can be, and the help that you have, with whether it's Karen or that has that expertise, it's knowing that you have something in your arsenal to make the informed decision for yourself. And I totally agree that frame that you said. You are the CEO of your be in your practice or in your strategy as a physician, 1,000%.
And it really is.
How
It's about
No, no, go
that
ahead.
decision.
Absolutely. Now, how do we get in touch with you? What's the best way? And talk just a little bit about your process and how someone can, if I was a physician, if I was, let's just say I'm in my, last residency going to fellowship or fellowship becoming attending, things like that in terms of where I am. How do I talk to you? How do I, come to be that, strategy for myself?
So for me, there is an article that hopefully you can post that has my contact
Absolutely.
information. I have a website, www.kdavidsonlaw.com. But for me, anybody who is interested in seeking our services, we always have an initial conversation with them to make sure that we're on the same page in the sense of timing. I'm a solo practitioner, so depending on what's happening at the time,
Sure.
may not be able to take a matter. But I also want in that conversation, it's usually about a half an hour. There's never a charge for any of that. We explain what our fees are. But I also like to give people, and maybe they've gotten it through this conversation that we're having, is a feel for the way that I work. And everybody's got
Yes.
different styles, and maybe my style isn't right for somebody. But from my perspective, maybe I do give it a little bit, right between the eyes, a little straightforward. But I will say that I have had a number of physicians come to me with complex offers and positions, whether they be private equity or otherwise. And honestly, I'm happy to say that they actually decided not to take those positions in part after seeking counsel because they were able to then look at it and decide that it was too much risk for their own personal comfort level. And 90% of the time, I am a cooperative negotiator. If someone says to me they want to make a deal, we do everything we can to get them to the place where they have a comfort level. But in finding more and more as healthcare becomes, more corporatized, for lack of a better,
Mm,
and more
mm,
business oriented.
mhm,
Lots of
mhm,
private equity investment
mhm.
in healthcare now. The large hospitals and health systems all merging to be very large entities. That decision making is actually for the physician is even more complex. So that's where I get my job satisfaction is helping people figure out what makes sense for them personally.
Well, thank you so much, Karen. I really can see your passion. I am so glad that you're able to help these physicians make the critical decisions for themselves, what matters to them and why they got into medicine in the first place, but yet help them, educate also on the business side. That is equally important. And yes, I will definitely in follow up at the end of our session today. Make sure I'll get to the article and post that, and then also post in your information. I just made a last peek and see if there's any questions. I did not see any other pertinent questions, but I hope that, with our listeners today, that they're able to take the information and absorb that. And if you need to reach out to Karen, I will have her information for you. And so thank you again, Karen. I walked away with so much information. Thank you for your education and just knowledge base that you have. I appreciate that.
Well, thank you for having me. It's been a pleasure. I just love having the engagement with you, Sharon. So thanks.
Likewise. Well, have a good day. Thank you, everyone. Thank you for listening.